Good afternoon, everyone. Australian legislation provides a so-called no-fault remedy for aggrieved rights owners against internet service providers whose networks are used for infringing copyright, regardless of whether or not the ISP has any knowledge of the infringement taking place. Now, the legal basis for this protection is grounded in Section 115A of Australia's Copyright Act, but the remedy didn't always exist. So this session, we'll examine the present state of online enforcement in Australia and how it all came about. Michael Williams is the head of the intellectual property group at Gilbert and Tobin, and his wide-ranging practice spans IP litigation, contractual disputes, particularly for software, product liability, entertainment law, media, technology, and innovation, among others. And throughout his career, Michael has advised and acted for many of the world's leading entertainment companies, creators, and trade associations in relation to online infringement, entertainment law, and raw reform. Now, in particular, Michael's been at the forefront of advocacy for the introduction of site blocking under Australian copyright law. And the cases he's brought and have been involved with help shape Australian jurisprudence, and that's what we'll be focusing on today. Michael, welcome. Thanks for taking the time to speak with us.
It's a great pleasure, Frank.
Can we begin with just a general discussion of copyright law down under? What are the current remedies that are available under Australian law to address online copyright piracy, for example, and how are they being utilized?
So there's really two broad pathways for copyright enforcement, particularly in the online environment. The first of the pathways is a more established historical approach based on proving fault for any of the operators in the chain involved in the alleged piracy. And the second pathway is the one that you mentioned initially in your introduction, which is site blocking, which is a completely different approach, which is a no-fault based response to online infringement.
And how do so could you break down a little bit further? It sounds like one is proving fault. Is that the actual infringement itself, or is there something involving responsibility for another person's activity?
Well, that's always the key question. But so proving fault is the first thing, as you've identified. Taking it right back to its origins, it's really identifying the infringing acts and who are the actors who can be found to have infringed within our jurisdiction. And that's the sort of base level of liability. Then the next level up from that is the ability to seek other people who have authorized that infringement. So they have a particular relationship to the infringement and maybe a particular relationship with the primary infringer. So the best way to look at that is to say primary infringers who are infringing the right of communication to the public, which is really the cornerstone of the fault-based copyright enforcement system in Australia, as well as authorizers, who are often those involved in facilitation, because they might design the software that's used for infringement. They might have a platform which is being used to their knowledge for infringement, or they might provide some other service which is involved in the infringing activity. And so in that way, even though they might themselves not be driving the fundamentals of the act of infringement, they're the ones who can also be brought into liability because of their relevant involvement. And those sort of principles based on primary infringer and an authorizing infringer have been pretty fundamental in the extensive development of copyright law in Australia and the enforcement of copyright online since at least 2000.
I mean, even before the online infringement, the concept of authorization liability extended to universities, didn't it? With respect to photocopying, so I recall a big case back in the 70s, if I'm not mistaken.
Absolutely, you're quite right. So Australia's been one of those jurisdictions that has had quite an active development of law around rendering facilitators liable in some cases. And the case you're referring to is known as Morehouse, very famous case in 1975 that established liability by universities for the kind of infringements that were being carried out using photocopiers on university campuses. And that resulted actually in a whole statutory license scheme for photocopying, as it turns out. But it was a very far-reaching case, which took liability well beyond just the students who were photocopying, to a much more sort of removed person who involved in running the actual photocopying service itself. So basically the photocopiers in the university library.
Which I suspect were just a machine to be used. The university didn't have an active knowledge about who was doing what or the purposes they were being used for. Is that correct?
It's quite correct. I mean, the way the court looked at it at the end of the day was to say universities ought to have known that people would be doing this using the photocopiers, but that involves, you know, as I think your question indicates, something of a leap in logic that goes, maybe it's not logic, but something of a leap between actual proven knowledge and what is likely to have occurred just by having photocopiers generally available to people.
I see. Now, if we fast forward it another, say, 30 years or so, and we talk about the internet online infringement, are there any significant cases that picked up that Morehouse principle and applied it into the online area?
Yeah, there certainly are. So really the game changer, Morehouse was really focused on authorization in a pre-digital environment, of course. And the game changer when it came to a digital environment was the enactment of the Digital Agenda amendments to the Act. And in short, they introduced the right of communication to the public, and that was specifically directed to the transmission of copyright files over the internet to a broader audience. Now, in that sort of situation, there were a number of cases we had the opportunity to run in the early 2000s to actually develop the jurisprudence in that area. It was very interesting at the time. Probably one of the most significant at the time in the jurisprudence was called Universal Music and Cooper. And that was a case that I had the opportunity to file on behalf of Universal Music against the operator of a website which had hyperlinks to a whole lot of pirate music, and against the ISP that was hosting that website that was physically located in Australia. So that was a very significant case because it not only tested the limits of this new right of communication, it applied that authorization law from that Morehouse decision and earlier decisions to a facilitator. And it went as far as, you know, rendering an ISP, and in fact, the director of the ISP, equally liable for the infringing acts of that particular customer.
How important was it in that case that the website was physically located in Australia?
That's a very good question. In many respects, that was not the touchstone of the decision, but it certainly assisted the court to draw that sort of jurisdictional and territorial nexus to Australia. But in fact, the finding in the case was it was sufficient that the files were travelling in and out of the Australian jurisdiction by wires, you know, over the internet. So it wasn't absolutely vital that that website was here. And in fact, the files themselves, interestingly in that case, were located outside Australia. And so what the court was prepared to find is that the acts that were occurring in Australia or promoting access to the files were sufficient to result in infringement, even if the files were perhaps located on servers in other countries, which sort of indicates that it's the location of the files themselves was not also determinant of whether or not there was going to be infringement under Australian law.
But it sounds like in this case, the operative knowledge of the website operator or imputed knowledge was significant as well, right? Correct.
Very significant, exactly. And I think that's a common theme to all of these types of cases and the way that the law is developed, which is coming back to the photocopiers in the university. There had to be circumstances sort of established, like by the university in that instance, and in Cooper by the ISP that he used, which would lead inevitably to infringement using those facilities.
Okay, so that's still, both cases sound like a nexus of responsibility or knowledge, if you will. But I guess what's going on now is quite, we began talking about, is quite different altogether, in that the ISPs essentially lack that requisite level of knowledge. They take a position that they have no idea what's going on. It's like putting something in a mailbox. How are we to know what's taking place? So how did we get from those earlier cases where the requisite knowledge, or the relationship, if you will, of the parties was so controlling, over to one in an online realm where knowledge goes out the window altogether, or sensibly does?
Yeah, well, that's a very good question, and that's really the journey that occurred in Australian copyright law between the early 2000s and 2012. And at that later point, we had the opportunity to actually test whether or not an ISP on a much, much bigger scale could be found responsible and liable as an authorizer, again, like the university model, for having customers who were using BitTorrent in order to exchange music files. And so that was a case that went all the way to the High Court, and ultimately the Australian High Court, the final arbiter of what the Australian law is, determined that the ISP was just too far removed by providing a general service to customers. And that was the case, even if the ISP had a suspicion that some customers were using the service to infringe, but that just wasn't close enough. And particularly wasn't close enough in terms of controlling the method by which they are infringing and being close enough to the individual acts of infringement. And so the court basically said, up until that point, it's possible for people who are facilitating to be liable, Cooper. There were other cases in the meantime, providing software and services, etc. But we reached this point in this decision of IONET where the court said, that's a bridge too far. And from that point, and the court said, essentially, this is for Parliament to solve. It's going to require a law to essentially require action on behalf of an ISP. We're not going to do it just by rendering a decision in the case. And that's really the stepping off point for getting to that different regime, particularly the site blocking regime and a no fault regime.
Okay, so, and that brings us, I suppose, to section 115A.
It does.
The legislative fix, if you will, for the judicial discrepancies or shortfalls, if you will. Got it. So, Michael, under section 115A, what are the various criteria that the courts consider when they're presented with a petition to block customers' access to an infringing site?
So there's a series of criteria. Many of them are mirrored in some of the legislation in Singapore, for example, around what has to be established for the particular site. You have to establish serious harm. You have to establish, a number of other criteria which would indicate that the site can be blocked in the local jurisdiction, and that it is not going to be an unfair or inappropriate blocking of legitimate content which could come into this jurisdiction. So there's a number of prescribed elements to the law. In practice, well, I should say before the law was tested, there was quite a lot of debate about whether or not the bar had been set too high, or in some circles they'd said it could be set too low before the court would make a site blocking order. The origins of the site blocking order are actually legislation that took a slightly different form, but that came from the United Kingdom. And it was left perhaps more open without a number of specific criteria under UK law, the so-called 97 A site blocking provision. But anyway, fast forward to Australia, the Australian government wanted to set a bar that was quite high, and it would require sort of only the worst or very substantially worst sites that were focused on infringement that could fall within this net. But what's interesting is that right from the get-go, the regime has actually worked quite efficiently. And while there were some initial disputes with ISPs when the first of the applications were filed, and the court was having to then determine what was the appropriate standard of proof that the website in question or the platform had substantially pirate material, etc. It was very quickly worked through in the cases, as occurred in the UK years before. And the result has been actually a very workable system, which is largely done on the papers these days without even a court appearance.
So it doesn't sound like site blocking has broken the internet.
No, it's exactly right. It's interesting you say that. In the whole sort of history of this evolution of enforcement, the phrase, it'll break the internet has come up numerous times. I mean, it was going to break the internet to introduce the right of communication to the public. Cooper was going to break the internet, but it didn't break the internet. Various other cases, even IONET was going to break the internet. And now site blocking, as you indicate, it hasn't broken the internet. And in fact, the internet's thrived as a result of site blocking for various reasons.
Yeah, indeed. Michael, what's the feeling? Why don't rights owners simply target individual infringers, however, rather than taking the trouble to go to ISPs and bring this authorization-based theory?
It's a very good point. It's a very, very good question.
Should the ISPs at the end of the day be responsible for what's going on, what the customers are doing online?
Well, that's a very good question, and it's a very contentious question. I think probably the answer to that question is once there was a debate about whether the ISP should have any responsibility whatsoever. And I think the debate has matured much more to what is the nature of the responsibility that they should have. And site blocking is an example of something where they don't have to be very responsible to be able to apply effectively technical blocks to incoming traffic from those sites and those URLs and domains. And sometimes there's a debate about to what extent the ISPs should have to kind of change as maybe sites move around and URLs change to try and avoid blocking. But we're in a very different world, which is now what is a fair compromise, particularly where the ISPs are not themselves liable. I think they've identified really the opportunity to avoid more IONET style accusations, more accusations around, knowing about the infringing content that's traveling over their networks, and instead being able to just focus on it being, just a technical process and a very minor cost of doing business, which is to apply blocks to the worst pirate sites. And, when it comes to a country like Australia, even though there'd been some debate about what would the effectiveness be of this kind of system before it was introduced, it was quite a lively debate. It's turned out to be effective because it doesn't require a lot of the ISPs. The rights owners still bear substantially the burden of identifying the sites that they would seek to have blocked. The courts deal with it in an efficient way. And basically, as a whole, it's shown that the vast majority, it's sort of confirmed that the vast majority of websites and essentially platforms and so on that are the source of the infringing material are actually fairly narrowly identified. In other words, it's a small number of sites, a small number of services which are responsible for the vast majority of the pirate traffic that's taking place over the internet and reaching people in Australia.
Yeah, I seem to recall hearing some of the research that was undertaken that concluded along the lines that if you are going to block sites, blocking one or two at a time really won't have much of an effect. But if you block a larger number of them, I think the numbers range from anywhere from 80 to 200, which is along the lines that you just mentioned. That does have a corresponding effect on infringing behavior and also the take-up of legitimate activity. Is that correct?
Yeah. And it's interesting. So there'd always been a healthy debate about the extent to which copyright enforcement would really assist in shutting down pirate activity, as well as offering legitimate services and legitimate streaming services. And there is no doubt that it's a combination of both. And in fact, probably in the history of it, it required, the environment needed to be essentially stabilized with copyright enforcement work in order to get to a point where legitimate services could get a purchase. And when they did, when you think about in a market like Australia, we're avid watchers of the screen and avid listeners to the digital music services, and that's actually what's eventuated. So once the kind of lock that the monopoly that the pirate sites had on streaming and easy downloading was broken, then it's given a fantastic opportunity for the legitimate services to get going, and they've well and truly outpaced the pirates now.
Yeah, I mean, it seems to me that when you look at society, you're always going to have a small amount of people at one end of the spectrum who are always going to pirate or download for free, no matter how easy or reasonable the alternatives are, just because they can, or contemptuous of the law, or come get me. There's going to be a small amount at the other end who will just never do it, no matter how easy it is to pirate, just for whatever reason. It's that 80 or 85% in the middle that could go either way. I think that the industry is literally looking to placate and to get reasonable. So how by that nature, how has the public in Australia reacted to these developments, ongoing developments over the past, from the sound of it, 10 years or so?
Well, look, I think overwhelmingly, they haven't been too concerned about the philosophical debates. In the early period when cases had to be filed and the only option was a liability-based claim and site blocking didn't exist, there was more contention around whether or not rights holders were going further than they should have gone, perhaps. But as I said before, it's probably more about clearing and stabilizing the environment. And in fact, when the High Court sort of drew the line at ISPs being generally liable for infringing transmissions across their networks in IONET, that initial setback for rights owners turned out to be the turning point. And since site blocking has been introduced, really the public has accepted it, and I think everyone has moved on substantially. So, it's a very, very good example of how a more creative solution was brought into the copyright regime, which actually took some of the pressure off the regime itself and off judges who previously had to find that someone was liable, or a network operator or an ISP was liable. That's a very big deal to get to that point. But this way, the courts could basically say, look, it's not about who's at fault in the local environment, it's about a shared problem. And this is a way of responding to that shared problem. And, because no one has to be targeted in that way, then, it doesn't, it doesn't create an issue amongst people in the public who are just happy to get their, music and their video content on their streaming service.
That's encouraging. So therefore, what are some of the latest developments? Is the process getting refined in any way? Could it be refined further?
Look, I think it can always be refined a bit to follow the technology. So initially, it was focused on what were really platforms and websites. It's now moved to a point where it's possible to get site blocking orders in relation to search. And so, and that is the result of, significant development as a result of real world examples. I think over time, as the technology that's used by people to get their music and their movies changes, there'll always need to be some capacity to be able to update, this regime. And I think that will tend to happen. At this point in time, I think the processes have kind of run their course. There are other rights owners who are outside those sort of core entertainment fields who have started to get into site blocking, because what they've found is those tools may be very useful for them, with other type of content, which is not typically streamed by way of music or video.
Could you give us a for instance?
Well, software companies are now looking at that as an option, because there's they're just arguably just as affected by essentially online piracy, and even rights holders in the publishing industry, so book publishing. In a world where increasingly people are getting their content to read, on their Kindle or some other device, it becomes a very big issue in that industry to have digitized books freely available on pirate sites. And, the capacity to kind of hollow out those types of industries is just as real for them as it was for the music industry and the film industry, 10 or 15 years ago.
Understood. So it clearly does sound like it's been a journey of sorts, both in terms of litigation as well as legislation down in Australia. What about more generally in the areas of cooperation? Is there any discussion about things like a code of conduct between the various industries that might preclude the necessity of going into court altogether?
Well, it's a very good question, and there've been, a number of attempts over the years to introduce codes of conduct and agree on codes of conduct, and pretty much those fell away because of the different interests of the rights holders and those who are running sort of the platforms and facilities. In a sense, those codes of conduct, they always had to kind of pick a winner and loser in particular circumstances, and they had to have very broad take up within those different camps. And what was interesting is that not every rights holder association or trade association agreed with the proposal, and so there were breakaways in the rights holder side, and the same is true on the user side. So there would be platforms and digital facilities and ISPs that would not share a common position amongst ISPs. And it became even more complicated when what you had was ISPs being acquired by content companies and vice versa. So it wasn't possible to actually sort of reach a code of conduct, despite the fact that the government encouraged it a number of times. And in a sense, the site blocking regime was introduced essentially to try and get past that disagreement after an attempt to go, firstly through litigation proper, then to go into, a code of conduct and negotiating that. And many of us were involved in that. And then when those things fell over, the government was asking essentially, what do we do next? And that was the exciting thing, to come up with more of a left field option, which is to say, let's park the thorny issue of liability and let's focus on it being a shared problem. What can we do in enacting a regime which focuses essentially on the problem and a solution, and less about whose fault it is that we're here? And that's essentially what's happened.
Yeah, that sounds like a very enlightened concept. So these remedies that we've been discussing, have they been applied in any other realms of jurisprudence beyond IP infringement in Australia?
Look, they haven't yet. So we don't have the equivalent, for example, of the Cartier decision in the UK, where that remedy was applied to trademark owners. It would certainly be a terrific remedy if it was available outside the Copyright Act. And there've been some discussion and some, advocacy for it to be expanded for that reason, because you could imagine brand owners the world over would have a similar interest in being able to stop access to pirate brands or misuse of trademarks through the same kind of device, and not have to get focused entirely on liability. But I suppose, unfortunately, the Australian courts have taken an extremely traditional view of the scope of the powers of the court. And in short, just like until the site blocking legislation was introduced for copyright, the courts have taken a consistent position that the court doesn't have jurisdiction to make orders like injunctions and actually stop facilitators or stop ISPs unless they're actually found liable themselves. So we have basically a legal system that in the IP rights area, with the exception of this site blocking regime for copyright, still requires findings of infringement. And while ever that is the case, the courts are going to refuse to grant injunctions and actually stop those other, facilities operators. And we're going to be left in this current position where it's all about finger pointing and blame.
Wow. So in some respects, we've gone full circles, and in some other respects, we haven't moved an inch.
That's it. That's a good way of describing it.
I wonder if that might not be a good place to conclude. Covered a broad ground of interest, a lot of topics. Any suggestions for rights owners, or any lessons that they might have learned at this point by virtue of the legislation that's led to the heightened enforcement mechanisms that are utilized today?
No, I think in a way it's different rights owners are sort of thinking about what their enforcement priorities would be. I think the enforcement environment has become very, very mature. I think the kind of extent of investment in enforcement activity has fallen away a great deal from what it was a number of years ago. Now, maybe that is a reflection of the fact that these things move in cycles, but maybe it's also a reflection of the fact that the hard yards were done early to try and move the dial from a position where, the internet was generally unpoliced and unpoliceable, which was certainly the case back in, say, 1999 when Napster was shut down in the US, but in Australia was just a name. Fast forward to where we are today, the strength of the legitimate services, the strength of the technology streaming content to people is such that, the majority of people are quite happy to get their content legally, happy to pay. The pricing of it, has improved dramatically over the years. And, as a result, if you want to be an inveterate pirate, it's probably hard work. So, when you think about it from the rights owner point of view, it's not necessary to go after quite so many people. It's not necessary to shut down the big networks. And maybe even the economics of the big networks aren't what they used to be. That is the pirate networks.
Understood. Michael, thank you very much for a very comprehensive discussion, for your expertise and your knowledge. Always a thrill. I wonder if we shouldn't turn it over to the audience now for questions.